Ladies and gentlemen, it's my pleasure to start the next panel off. My name is Peter Hogg. I'm the chair of the panel. The topic of the panel is Senate reform once more. We have three very interesting panelists, and the order in which they will speak is the order in which they are sitting. Immediately to my right is Kate Glover, who is a doctoral candidate and Vanier Scholar at McGill, and she clerked with Madam Justice Abella in the Supreme Court, and she was one of the amicus curiae, one of the amici curiae, I suppose, in the Senate reference itself. So she has been involved in the litigation. I've been trying to send a message to the court that we wanted the decision by today, but they were completely impervious. So we don't have to speculate about what they're going to say. Then Warren Newman. Warren is Senior General Counsel in the Public Law Sector of the Department of Justice. He also was counsel in the Senate reference, representing the Attorney General of Canada. And Warren, as everybody knows, is also an accomplished scholar and teacher, as well as being a very senior official in the Justice Department. And our third speaker is Richard Albert. And Richard is a constitutional law professor at Boston College Law School. He clerked with Chief Justice Beverly McLaughlin, as well as earning degrees from Yale, Harvard, and Oxford. And he has become a very accomplished and productive scholar. That is all I will say in the way of introduction, and I'll ask Kate to make a start.
Absolutely. Thank you, Peter. And let me just begin by saying thank you to the organizers for inviting me to speak today. I'm delighted to be here and participating in the conference and being part of the Osgoode Constitutional Cases conference community, which I can already tell is a very warm and inviting one. And I'm delighted to be here today to speak about Senate reform and the reference, as we all eagerly anticipate and wait for a decision from the court. Now, today, I would like to speak about the role that constitutional structure can play in resolving some of the legal issues at stake in the Senate reference. And by the end, I hope I will have shown you that first, constitutional structure is at the heart of the interpretive questions at stake in the reference. Second, that there are multiple types of constitutional structure that matter. And third, that structure is not merely a matter or an interpretive matter, but is a matter of substance. Now, to get you excited about constitutional structure, I think the easier way would be to talk directly about the Senate and the proposals for Senate reform that are on the table in the reference. That is definitely a structural issue. But instead of taking that easier route, I'm going to try and get you excited about constitutional structure by talking about the main question that is at stake in the reference, which is how should we go about interpreting Part 5 of the Constitution Act 1982. And more specifically, I'll speak to three ways in which constitutional structure provides the framework or the parameters for interpreting Part 5. And so this is more of a preliminary question in the reference. And then I'll conclude with some comments on how these lessons may be important for the court going forward. Now, I'm sure I don't need to do this, but just a brief refresher on Part 5 for anyone in the room who doesn't live and die by constitutional amending formulas. Part 5 is a self-contained code within the written Constitution, and it sets out which orders of government, in what numbers, must consent in order to formally amend the Constitution. And generally, the degree of consent that is required depends on the subject matter or the scope of the proposed amendment. So, for example, an amendment, as we know, in relation to the composition of the Supreme Court requires unanimous consent of Parliament and the provincial legislatures. An amendment in relation to the powers of the Senate or the method of selecting senators triggers the 750 rule. And with some exceptions, an amendment in relation to the House of Commons or the Senate can be done by Parliament alone. And the interpretive difficulties that come up arise in trying to figure out the scope and the meaning of these subject matters and how the different amending formulas fit together. And the court has never interpreted Part 5 in this holistic sense, and the Senate reference is its first opportunity to do so. So let me turn to my first lesson, and this emerges from a traditional structural analysis. And the lesson is that the animating spirit of Part 5 is found in the foundational unwritten principles of our Constitution, the ones around which the entire Constitution is constructed. Now, we know that the court often engages in this traditional form of structural reasoning in constitutional cases. It interprets the Constitution by drawing inferences from the institutions that the Constitution creates and the relationships that the Constitution creates between those institutions. And we see this kind of reasoning, for example, in every division of powers case, as the court determines the scope of legislative power by as a manifestation of its understanding of federalism. And of course, we saw it in the Supreme Court Act reference. I don't want to call it the Nadon reference, the Supreme Court Act reference. Where the majority used a historical and a structural analysis to conclude that the court is now a foundational premise of our constitutional order and is therefore entrenched within our Constitution. Now, in the Senate reference, the structural issue is not whether the proposed reforms to the Senate enhance or diminish our constitutional principles. The issue is not whether advisory elections or term limits for senators would make the Senate more or less democratic. Rather, the key question from a structural perspective is how can the structural principles, the unwritten principles of our Constitution, inform the way that we interpret Part 5 and how we appreciate our amending formulas and the amending process. And the answer, as I said, I think, is that the unwritten principles give life to Part 5. On its face, Part 5 seems like a fairly formal and technical collection of amending formulas. But the structural principles provide context for Part 5 by revealing the tensions that underlie it and the values that our amending formulas can be said to embody. So if we read Part 5 as infused with our constitutional principles, cooperative federalism, democracy, constitutionalism, we see that the amending formulas are not random or eclectic, right? They are a distinctly Canadian attempt to address the idiosyncrasies and anxieties that have arisen in Canada's history of constitutional amendment. For example, in the spirit of constitutionalism, the rule of law, and democracy, Part 5 is intended to ensure that parts of our Constitution are entrenched beyond majority rule. So Part 5 is the primary mechanism for safeguarding our formal constitutional order against unchecked attempts at change. And the interpretation of Part 5 will be a statement about the strength of our commitment to protecting that order. Another example, in the spirit of balancing the demands of democracy and cooperative federalism, Part 5 creates a scheme that requires intergovernmental cooperation when joint interests are at stake. So Parliament and each of the provincial legislatures have exclusive authority to amend the Constitution in ways that only affect their interests. But they must come to some degree of consensus when an amendment engages the interests of both orders of government. Now, of course, reading Part 5 through the lens of these principles can also raise concerns about the limitations of Part 5, in particular with respect to whose consent is not required in order to, in the process of amending the Constitution. Aboriginal peoples, minority interests, and the territories as well. And the court, of course, can't use, well, might be arguable, but it can't use the unwritten principles to support an interpretation of the text that the text can't reasonably bear. And so this issue as to who else might be included came up at the hearing, and we'll have to wait and see how the court deals with this and whether or not this consent issue exists within Part 5 or in the parts of the Constitution outside of Part 5. So this brings me now to the second lesson that we can learn. And this also has to do with interpretive method. And the lesson shows that traditional structural analysis alone is an incomplete account of how structure can contribute to understanding Part 5. So under the traditional structural analysis, we're interested in the institutions that the Constitution creates, the relationships between them, and the values that they are said to embody. But there's another type of constitutional structure that is relevant to our interpretation of Part 5, and that is internal or formal structure. So an internal structural analysis asks us to look at the formal elements of Part 5, the form and style of each provision, and the way in which they are arranged and presented. And this kind of structural analysis reminds us that there are countless ways in which the amending formulas could have been entrenched within our Constitution. And the framers of Part 5, they weren't bound by any particular procedure or any particular articulation of that procedure. They made particular choices. And an internal structural analysis of Part 5 means that we ask, are there any interpretive lessons to learn from those choices? And with respect to Part 5, I think the answer is yes, and let me just point to one example of how this plays out. So the formal structure of Part 5 shows that Part 5 is intended to be a complete code. It is structurally designed to capture all possible formal amendments to the Constitution of Canada. And we see this in the fact that the amending formulas are arranged as a series of exceptions and variations around a general rule. And the general rule is residual. So when a proposed amendment does not trigger any of the exceptions or variations, then the general rule applies. So no formal amendment will be left behind. They'll all be captured within Part 5. And as a result, the interpretation of Part 5 must be sufficiently precise to give a stable answer, a predictable answer in any particular case, while at the same time being sufficiently flexible to endure over time. And that's the challenge in interpreting the subject matters that are listed within Part 5. So let me turn quickly to the third lesson, which raises another type of structure which is relevant to understanding the meaning of Part 5, and that is analytical structure. So looking at Part 5 on its face, it does not explicitly provide for a framework for assessing any particular constitutional amendment and trying to determine which formula applies. But if we read Part 5 with attention to its logic and its structure, and in the greater constitutional context, we see that Part 5 contemplates a two-step analytical framework. And I'll just make a few points about that framework. So the Constitution is made up of many different parts, and these parts are legal and political, written and unwritten, entrenched and unentrenched. And at the same time, there are many ways in which the Constitution can change. Judicial interpretation, constitutional convention, institutional evolution, legislative enactment, or by virtue of Part 5. Part 5 is just one way in which the Constitution can change. But it is the least flexible, and it has serious consequences, right? It is the way that we change our supreme law. And in light of this variety in the Constitution and the consequences of Part 5, there must be a threshold question that determines whether or not Part 5 is triggered in any particular case. And this is so that we can make sure that Part 5 is triggered in the appropriate cases and is not triggered in those cases that can proceed without the formal rigors of Part 5. So the first question in any analysis must be, is the proposal in question an amendment to the Constitution of Canada for the purposes of Part 5? Does it fall within the scope of Part 5? Now, this question will seem trite in many cases because if a proposal actually proposes to add or delete any language from one of our constitutional documents, then the threshold test is obviously met. And then the second stage of the analysis, where we determine which formula applies, will be the only step where there is any real work to be done. And this is the case with most of the reference questions in the Senate reference. But the threshold question remains important, and the Supreme Court Act reference shows that what constitutes an amendment for the purposes of Part 5 is not always obvious on the face of an enactment or a proposal. And so the second reference question in this Supreme Court Act reference is actually a debate about this threshold question. And a similar dispute is at stake in the Senate reference, as the court must decide whether or not the legislative proposals for advisory elections trigger Part 5. And the dispute there is raised because the legislative proposals don't actually add or delete any language from any of the constitutional texts that are listed in Section 52.2. So to wrap up, let me make one general comment about Part 5 and the role of the courts. So the exercise of interpreting Part 5 reveals another structural lesson, and that is that the design of Part 5 all but guarantees an active role for the courts in the process of formal constitutional amendment. So the framers of Part 5 could have entrenched a uniform amending process for all possible amendments, but they didn't. Instead, we have multiple amending formulas. And the subject matters expressly listed in those formulas touch on some of the most controversial issues that plague Canada's collective constitutional psyche. And they are all subject to interpretation. And in our constitutional climate, that interpretive task will frequently, not always, but frequently fall to the courts, whether through ordinary litigation or through references. And perhaps the chances of triggering the judicial process are greater when the proposed amendment itself bears on the architecture of our fundamental institutions, whether the Supreme Court through the Nadon reference, or the Senate through the Senate reference, or the Office of the Queen through the challenges that are currently ongoing to the Succession to the Throne Act. But in any case, while critics often lament the fact that patriation bestowed greater power on the courts through the Charter, it shouldn't be forgotten that the courts also secured a significant grant of power through the very design of Part 5. Now, on this point, it's also worth pointing out that the court's impact on constitutional amendment process can be indirect as well. So the political realities, as we all know, of amendment already make it very difficult to amend our Constitution through Part 5. And the court's interpretation in the Senate reference could very well contribute to that chilling effect of formal amendments. On the flip side, of course, a chilling effect on formal amendment could create the conditions in which informal proposals and procedures for reform can be imagined in a greater sense. Thank you.
My timer here.
I thought I'd lost Warren, but actually was where he's supposed to be. Our next speaker is Warren Newman.
Thank you, Peter, Professor Hogg. I too must say it's a great pleasure to be here back in the Osgoode constitutional cases setting. I presented a paper here about 5 years ago called the Constitutional Status of the Supreme Court, and I do not intend to do anything so groundbreaking today. In fact, it was with some diffidence that I accepted to speak and especially to present a paper, given that the court has not rendered, and I won't call it a decision, it's advisory opinion yet on the Senate reform reference. But I do want to take the 15 minutes or so that are allotted to me to address 7 propositions. I have 7 propositions in 7 pages. I think that's sort of a lucky coincidence. And you can pull up the paper if you want to look at it. It's really an outline of a paper, because until the court, in its infinite wisdom, comes forth with its opinion, obviously much of this will be necessarily tentative. Not the propositions themselves, but perhaps the emphasis to place on them. So my first proposition for you, and these are based on really first principles, and some of you will consider these trite, but I think they bear repeating in this setting. The supreme law of Canada is exactly that. It's law. Section 52 of the Constitution Act 1982 renders invalid legislative measures that are inconsistent with the provisions of the Constitution. We find that so many words, at least in the English version of Section 52. It's the law of the Constitution that is supreme and entrenched. It brings that discipline in terms of the hierarchy of norms to constitutional analysis when it comes to see whether legislative measures are intra vires or ultra vires in respect of legislative grants of power by the Constitution. The documents, the acts and orders that are listed in the schedule to the Constitution Act 1982 are legislative and legal texts all. And so it's not without reason that Dicey spoke of the law of the Constitution. And we can differentiate the law of the Constitution, of course, and this is my second proposition, from the conventions of the Constitution, which played a very important role in the patriation reference, as you'll recall. The conventions of the Constitution are normative. They are rules, but they are political rules. They're non-legal, customary understandings that bind political actors. The court went so far in the patriation reference to say that this does not undermine their importance, that some constitutional conventions are more important than the legal rules that they channel or the exercise of discretion that they may control. And the court went on to say that the matter might be expressed as an equation, that constitutional law plus constitutional conventions equals the total constitution of the country. Now, where do unwritten constitutional principles, structural underlying principles fit in that equation? The court relied on them in the patriation reference because the principles of federalism and democracy were the raison d'être, as the court said, using the Jennings test of the convention the court discovered of substantial provincial consent to amendments to the major amendments to the Constitution, which were at issue in the patriation context. I would say, and I do say, that constitutional principles straddle the divide between law and convention. They act as legal principles when they're used to construe the text of the Constitution, the provisions of the Constitution. They act as political principles when they are employed to found or undergird constitutional conventions, such as the conventions of responsible government. The fourth proposition is that in 1982, Canada moved from a largely convention-driven process of constitutional reform to a set of reasonably precise legal procedures set out in the provisions of the constitutional text. And our colleague Kate has just taken you through some of those in the context of Part 5 itself. I would posit that those provisions, and Part 5 in particular, are essentially a rules-based part of the Constitution. They're not open-textured. They don't invite infinite variations on a theme. And it is important for political and constitutional actors to be able to understand just what the scope and ambit of those rules are. The procedural rules must, in principle, be cognizable in advance so that rational actors can plan their proposed reforms and devote energy and public resources accordingly. A rule that is unknowable is no rule at all, and it runs contrary to the principle of legal constitutionalism and the value of a written constitution promoting legal certainty, and its function as an entrenched and supreme body of legal norms and positive law. My fifth proposition is that a proper reading of the multilateral procedures of the Constitution reveal a dual purpose. First is to permit constitutional amendments where the legal requirements of the formulae have been met through the authorizing resolutions of the relevant federal legislative bodies, chambers, and the provincial legislative assemblies. The second function, of course, is to protect constitutional provisions and entrenched guarantees from change where the requisite conditions of Part 5 have not been met. And as is the case with other manner and form provisions of the Constitution, failure to meet the formal procedural requirements mandated by the provisions will result in the invalidity of the proposed measures. However, the obverse is equally true. Where those legal requirements have been met, the amendments will be valid and effective alterations to the law of the Constitution. The sixth proposition is that Part 5 itself grants legislative authority to Parliament and the provincial legislatures to amend, within prescribed limits, certain of the textual provisions of the Constitution of Canada. Section 44 of the Constitution Act 1982 explicitly provides, and I quote, that Parliament may exclusively make laws amending the Constitution of Canada in relation to the executive government of Canada or the Senate and House of Commons. That this is subject to the overriding application of the more stringent procedures of constitutional amendment contemplated by Sections 41 and 42 for certain specified matters does not negate or deny the manifest character of this grant of legislative power to amend the Constitution in relation to certain federal institutions. So too, Section 45 grants to each provincial legislature the power exclusively, and again I quote, to make laws amending the Constitution of the province. But that power, of course, is also subject to Section 41. The seventh, and for this purpose of this conference, my final proposition is that the Constitution of Canada grants legislative authority to Parliament and the provincial legislatures to enact, again within prescribed limits, constitutional law in the organic sense described in the Osgoode case, the late Mr. Justice Betts. That is, bearing on a principle or an institution of government. The source of legislative authority for provincial legislation of this character was Section 92(1), thank you, of the Constitution Act 1867, or the British North America Act as it then was, and is now Section 45 of the Constitution Act 1982. The principal source of legislative authority for federal statutes of a constitutional, quasi-constitutional, or organic nature has been the general or residuary power of the Parliament of Canada to make laws for the peace, order, and good government of the nation. It is found in the introductory words to Section 91 of the Constitution Act 1867. And arguably, Section 44 might have the same scope as Section 45, which allows both for textual amendments to the Constitution and the enactment of organic legislation. The power to enact by way of ordinary legislation and ordinary legislative processes, constitutional or organic legislation, allows for a certain amount of flexibility and democratic experimentation before proceeding, or not proceeding as the case may be, with formal constitutional amendments. Quasi-constitutional statutes must, of course, be consistent with the provisions of the Constitution, or they will, if challenged, suffer the fate of invalidity, pursuant to Section 52 of the Constitution Act 1982. However, as long as they do not contradict or circumvent the thrust of the provisions of the supreme law, such statutes may have the virtue of enhancing or advancing the implementation of constitutional principles, including federalism, democracy, and the protection of minorities, or in rendering the formal rigidity of certain aspects of the Constitution more adaptable to changing social circumstances and values, short of formal constitutional amendment. Now, there is no doubt that the enactment by Parliament of the First Official Languages Act in 1969 paved the way for the later entrenchment in 1982, as part of Canada's supreme law, of the guarantees set out in sections 16 and 20 of the Canadian Charter of Rights and Freedoms. The validity of that 1969 Act was challenged as going beyond the fundamental Confederation compromise as to the official use of the English and French languages embodied in Section 133 of the Constitution Act 1867. The Supreme Court upheld the validity of the Official Languages Act as an exercise of Parliament's residuary power on the basis that as long as the limited constitutional guarantees of Section 133 were respected, Parliament, the provincial legislatures acting within their respective spheres of jurisdiction could enhance or advance the equality of status and the use of English and French. Most of the questions submitted to the Supreme Court by the Governor and Council in the Senate reform reference turn on the scope of the legislative authority of Parliament to amend the provisions of the Constitution, pursuant to Section 44 of the Constitution Act 1982, or to enact legislation that does not amend the provisions of the Constitution, but that moves beyond them in ways that are nonetheless, it has been argued, consistent with the wording and thrust of the constitutional text, as well as underlying constitutional principles. The final questions before the court, and I'll finish on this note, necessitate an examination of the relationship between the general amending procedures set out in Section 38 and contemplated by Section 42 and the unanimous consent procedure of Section 41 in relation to the abolition of the Senate. In other words, would the reconfiguration of Parliament, as henceforth consisting of the Queen and the House of Commons, engage in pith and substance the 750 procedure as an amendment, for example, in relation to Section 17 of the Constitution Act 1867, which constitutes Parliament? Or is it subject to the unanimity procedure as an amendment in relation to the amending procedures themselves? To say more at this juncture would be unwise. Thank you.
Richard Albert is our final panelist.
Morning. Today I'll take a comparative perspective on the Senate reference, and my main comparator will be the United States. And the question I'd like to explore with you is whether Section 44 is the correct source of authority for amending Senate selection. The larger question that lurks beneath concerns the relationship between legality and legitimacy. Specifically, is it possible that what is legal is not always legitimate? And that's the ground I think I'd like to cover this morning. First, I'll explain the concept of unamendability, and I'll illustrate the related concept of constructive unamendability. Then I'll explore whether the Government of Canada's effort to formally amend Senate selection using the unilateral federal amendment procedure in Section 44 amounts to an improper circumvention of the multilateral general amendment procedure in Section 38. I want to interrogate whether the Government of Canada's use of Section 44 to formally amend Senate selection may be both legal in form, yet illegitimate in substance. But first, before I begin, I want to thank Jamie for inviting me, and Ben. Good to meet Ben for the first time, my fellow McLaughlin clerk the year before me. I took his seat in the office. And Peter and Warren, it's really a treat for me to sit alongside both of you. I've learned so much from your work, and it's a pleasure. And Kate, wonderful to meet you. And today I feel like this little boy up here on the picture. I live and work in the United States, although I'm Canadian. And we don't have nearly enough discussion of Canada and the U.S., and to have a full day of that today is really, really special. So thank you again, Jamie, for your invitation. So an unamendable constitutional provision can't be amended formally. It's designed to be unalterable and intended to be a permanent constraint on the state and its citizens. Constitutions around the world commonly entrench provisions against amendment. Germany, for example, makes federalism unamendable. Italy makes republicanism unamendable. And Brazil makes constitutional rights unamendable. In Turkey and Togo, secularism is unamendable, as is theocracy in Iran and Afghanistan, socialism in Cuba, political pluralism in Portugal. I could continue. Formal unamendability has become a standard feature in the design of modern constitutions. But neither the Canadian nor the United States constitutions currently entrenches formal unamendability. However, both constitutions entrench a peculiar form of unamendability that I have elsewhere called constructive unamendability. Constructive unamendability derives from a political climate that makes it unlikely, though not impossible, to achieve the requisite supermajorities to pass an amendment. Constructive unamendability does not result either from formal constitutional design, nor from interpretive constitutional law, but rather from constitutional politics. Constructive unamendability derives from deep divisions among political actors who reach the point of stalemate in their dialogic interactions. The stalemate itself may result from political incompatibilities, from unpalatable preconditions to amendment, or a simple unwillingness to entertain thoughts of amendment, despite a constitutional text that authorizes the change that political actors are unwilling to attempt. Alternatively, or in addition, the stalemate may derive from the structural design of the Constitution. For instance, a complex horizontal and/or vertical separation of powers that creates multiple veto points along the path to amendment. And so a constitutional provision or principle is therefore constructively unamendable when the constitutional text defines it as freely amendable, but the political reality dictates that it is not, in fact, amendable at that time. For example, the first Constitution of the United States was called the Articles of Confederation. Under that amendment rule in the text, all 13 states had to agree to an amendment proposal. Now, these 13 states could theoretically satisfy this demanding unanimity threshold, but in practice, this unanimity was not realizable and it failed many, many times. So, although the constitutional text authorized constitutional amendment, it was an illusory power because it was impossible to achieve the necessary majorities. A modern-day example of constructive unamendability appears also in the U.S. Constitution. The general amendment rule in the U.S. requires Congress and the states, respectively, to propose an amendment by 2/3 vote and to ratify it by 3/4 supermajority. Under the Equal Suffrage Clause, quote, no state, without its consent, shall be deprived of its equal suffrage in the Senate. Each state in the U.S. has 2 senators, and this clause preserves that equality by creating an exception to the general amendment rule. You need the consent of the state, whose representation in the Senate will be diminished before you can deprive that state of its equal suffrage in the Senate. Now, according to the constitutional text, the Equal Suffrage Clause is fully deployable to diminish a state's representation in the Senate. But as a matter of political reality, the text creates an illusory expectation. State representation in the Senate is therefore constructively unamendable because no state would consent to losing one of its 2 senators. Now, Canada has its own example of constructive unamendability. Senator selection is constructively unamendable, not because it is legally unamendable as a matter of constitutional design, but rather because political actors cannot realistically expect to assemble the constitutionally required supermajorities to amend it. By its terms, the default multilateral amendment procedure in Section 38 must be used to amend senator selection. That's what Section 42 tells us. This requires, as you know, approval resolutions from both houses of Parliament, in addition to approval resolutions from 7 provinces representing half of the population. The impossibility today of satisfying the requirements of this default multilateral amendment rule is what makes senator selection constructively unamendable. The deep and broad political agreement required across both levels of government is what dooms the prospect of amending almost anything using this default multilateral amendment procedure, let alone Senate selection, which is a deeply contested matter of long-standing political and historical complexity here in Canada. So just as the equal suffrage clause is freely amendable according to the constitutional text, yet practically unamendable in light of the prevailing political forces, senator selection here in Canada is indeed amendable under the Constitution, but the evolution of Canadian federalism has made it virtually inconceivable to amend senator selection using the multilateral general amendment rule. Now, in our present political climate, amending either the equal suffrage clause, you might want to see this, Peter, this picture right behind you. Amending either the equal suffrage clause in the United States or senator selection in Canada using Section 38 seems impossible. Both raise considerable political barriers to constitutional change, barriers that are anchored deeply within the structure of federalism here. But there is a way to amend both of these constructively unamendable features. The problem, however, is that the strategy that political actors must adopt in order to amend both of them arguably arises to what a French democratic theorist has called fraude à la Constitution. In translation, fraud upon the Constitution. Let me stress the arguably here. I'm not suggesting this point, I'm not making a final conclusion, I'm just suggesting this point for our academic purposes. So for this democratic theorist, political actors perpetrate constitutional fraud when they mask their intent to violate the spirit of the Constitution by adhering strictly and legalistically to the Constitution's textual rules. It is therefore possible for political actors to act simultaneously, legally, and illegitimately. Constitutional fraud occurs where political actors exploit legal rules to achieve ends that are inconsistent with the constitutional framework within which those legal rules are embedded. The constructively unamendable equal suffrage clause in the United States is amendable using this formalistic approach of constitutional fraud. How? Well, this clause is not itself entrenched against amendment. Political actors could therefore employ a double amendment strategy. First, repeal the prohibition on consentless diminishments of a state's Senate representation, and then do what the prohibition had prevented you from doing in the first place. This strategy is legal in a strictly legalistic sense, but it's illegitimate insofar as it allows political actors to achieve the very outcome that the equal suffrage clause was designed to prevent. Political actors in Canada could suggest that senator selection is susceptible to amendment under a similarly legalistic approach that may in fact be illegitimate. One could argue that this reflects the strategy of the government of Canada that it's taken right now in Senate reform. So Bill C-7 is the Senate Reform Act, the government's effort to amend senator selection. Bill C-7 is also the predicate for the reference to the Supreme Court of Canada on Senate reform. And this bill proposes a framework for provincial and territorial elections to fill Senate vacancies. It requires the Prime Minister to consider senatorial nominees for recommendation to the Governor General from a list drawn on the basis of these elections. The bill also proposes to establish a single 9-year term for senators. Bill C-7 therefore seeks to amend the Constitution Act of 1867 in at least two ways. First, it expressly proposes to amend the Constitution Act of 1867 by imposing term limits where none have existed before. And second, it proposes implicitly to informally amend the Constitution Act of 1867 by altering the subsidiary procedures by which the Governor General appoints senators. By convention, as we know, the Prime Minister currently enjoys discretion in selecting whom to recommend to the Governor General for a senatorial appointment. Bill C-7 shrinks the Prime Minister's discretionary authority by requiring that the Prime Minister must consider the provincial and territorial election winners. Now, the purported jurisdictional authority for Parliament to pass Bill C-7 relies on the unilateral federal amendment power in Section 44 of the Constitution Act of 1982. Under Section 44, Parliament may amend the Constitution of Canada, quote, subject to Sections 41 and 42 in relation to the executive government of Canada or of the Senate and the House of Commons. Under Section 38, all parts of the Constitution not otherwise assigned to another procedure must be amended by approval resolutions from both houses of Parliament, as well as resolutions from the provincial legislatures of at least 7 of Canada's provinces. Section 42 makes this default procedure mandatory for specific items, including Senate powers and provincial representation, as well as senator selection and eligibility. Section 44 is a very narrow power. It replaced the now repealed Section 91(1) of the Constitution Act of 1867, which gave Parliament limited powers of formal amendment. Matters subject to amendment under this federal unilateral power of amendment under Section 44 include things like parliamentary privilege or legislative procedure, and maybe the number of members of Parliament. In fact, certainly the number of members of Parliament, but not such foundational matters as senator selection. And so in invoking this narrow unilateral federal amendment power as a basis to amend senator selection, the government of Canada has either distorted Parliament's constitutional authority or attempted to achieve unilaterally what it is constitutionally required to pursue multilaterally. Now, observers can surely understand, thank you, Peter, observers can surely understand why political actors would choose this unilateral federal amendment procedure over the default multilateral amendment procedure. History has shown that it is difficult to amend the Constitution of Canada using this default multilateral amendment procedure. In fact, it's only been used once successfully. So something just doesn't look right with using Section 44, not when Part 5 appears to direct political actors to use the multilateral amendment procedure in Section 38. It doesn't seem constitutionally correct. There may be some sleight of hand happening. One can appreciate, however, why political actors would want to circumvent the default multilateral amendment procedure in Section 38. But we can interpret the choice as politically motivated without accepting it as constitutionally legitimate. Consequently, I think it remains an open question whether the government of Canada's use of Section 44 to amend senator selection is indeed an example of fraude à la Constitution. Now, to be clear, this is an inquiry, not a conclusion. The current effort to amend senator selection arguably reflects a disjuncture between legality and legitimacy. It could perhaps arguably be legal to use Section 44 to amend senator selection, insofar as it does authorize Parliament to make amendments to the executive government of Canada or the Senate and House of Commons. But the architecture of our amendment rules suggests that it may be illegitimate to use Section 44 to amend something as significant to Canadian democracy as senator selection. Using Section 38 appears more consistent with Canadian history, the evolution of the design of our amendment rules, and just more consistent with the centrality of federalism to democratic self-government here. Whether amending Senate selection with Section 44 is legal and legitimate, of course, remains to be determined, not just by the Supreme Court of Canada, currently deliberating on the reference, and I'm just about to close, but also by political actors in their chosen path toward the elusive and perhaps illusory promise of Senate reform, if indeed they ultimately choose to press ahead, which they might not. Whether political actors use either the unilateral procedure or the multilateral procedure, it's the Canadian electorate that will make the final judgment on the legitimacy of Senate reform. And in conclusion, in a constitutional democracy where political actors are bound by the rules entrenched in a written constitution and also by the norms anchored in our unwritten conventions, there could be no other way, nor indeed a better way, than for the people to have the final word. Thank you for your attention.
Thank you, Richard. That completes the panelists. Now, we have a lunch scheduled for 12:45, which gives us about 20 minutes when we could entertain questions. I will not let it go into the lunch hour. I'm told that that's an iron principle that the moderator must respect. But if there are people with questions or comments, would you please do as you've done in previous sessions? Come up to the microphone, introduce yourself, and pose your question or comment.
Hi. David Schneiderman, University of Toronto. A point of information, Richard was claiming that the feds were relying on Section 44, the unilateral amending formula, and maybe Warren can clarify this. I thought the argument was that they were relying on the Peace Order and Good Government General Authority in Section 91 and steering clear, I thought, at least in the factum of from the unilateral amending formula. But my question actually is this. Trying to think through the disagreement between the debate between the two sides in this case, and a lot turns on the ways in which each side sees a probability of success. So, and this question is not directed at anybody in particular. So the folks on the provincial side, and conventional wisdom, I think, amongst the legal academy, is that this will be a done deal, right? If the feds succeed in enacting the law and getting things up and running, it'll be done, right? There'll be no going back. And on the other side are those, I think, like me, who are more inclined to say, well, there's no it's not necessarily going to succeed, right? You need provinces to be complicit in the Senate election program. And there's even less likelihood now than there was even several years ago that a good number of the provinces will participate. So are those who say there's actually no probability of success. What the intention here, I think, is to try and create, curiously, a convention using legislation as a triggering mechanism. So I'm wondering whether this is a good way to understand the debate and what the amending formula can tell us about characterizing a law that turns on these two different perspectives on the law, on likelihood or probability of success. It seems to me there's no clear answer that the amending formula can give us around this. Thanks.
Well, I'll respond first then. First on the clarification. Certainly Section 44 is the source of legislative authority that was invoked for the textual constitutional amendment that Richard also referred to, the amendment in relation to Section 29 of the Constitution Act 1867. That would be an amendment, an explicit amendment to a provision of the Constitution, and thus Section 44 would be the source of legislative authority. You're certainly right, though, to point out that on the questions relating to the enactment of the various measures that have been put forward since 2006, 2007, to provide either for a national process of consultative or advisory elections, popular consultations, or in the context of Bill C-7, simply promoting a framework, a model legislation by which the provinces would enact under their own authority, assuming they have it, legislation along the lines of Alberta's Senatorial Selection Act. That would be, I'm sure Professor Hogg would agree, that would normally be characterized as an exercise of the residuary or general power under Section 91, although some scholars made an argument, and I developed it in a paper back in 2003, that Section 44 ought to have the same ambit as Section 45, since 45 can be used both for explicit amendments to the Constitution of Canada and the enactment of provincial organic legislation. Why can't 45 support amendments to the Constitution of Canada in a small c constitutional sense? But you're right, that got a rather light touch in the factum. I mean, we rely mainly on peace, order, and good government. On the other issue, just very quickly, and maybe Richard wants to, or Kate would like to respond. The only thing I'd like to say about, I was very intrigued by the presentation on legitimacy, as I was on structuralism. And of course, in Canada, constitutional legitimacy is largely controlled through constitutional convention. I mean, that is the point of constitutional conventions, to channel or stop the exercise of formal legal authority or discretion to accomplish certain acts. The question one would have in relation to Bill C-7 is, how does legislation which would require the Prime Minister to consider, only to consider, the democratic input of provincial and territorial populations into the appointments process, how is that immediately illegitimate? That's the sort of question, I think, that those who are the proponents of this legislation ask themselves. When we compare it with the current situation, where obviously the Prime Minister has a completely free hand to choose whomever, and we've got the Senate we have. So I would just throw that out there. Thanks.
Richard, would it make sense for you to respond on that, and then perhaps Kate after?
Sure. David, thanks for your question. So you got a clarification to your first inquiry, so we're fine with that. The second point you made was quite fascinating about conventions. I'm actually working on a paper right now called Constitutional Amendment by Stealth, which develops the idea that in light of the difficulty of formal amendment, political actors in Canada have sought to amend the Constitution in this roundabout way through convention. And so the way I define constitutional amendment by stealth is that it occurs when political actors consciously establish a new political practice whose repetition is intended to bind successors by creating a popular expectation that they will conform their conduct to it. And over time, this new political practice matures into a constitutional convention, which, though unwritten, effectively becomes entrenched in the Constitution. So I do think that this is happening, or the attempt is happening, not only with regard to Senate selection, but in the paper I'll develop 2 or 3 other examples where I've seen this current government try to do that. So yes, I agree with you that that's exactly what we seem to be seeing. Although I think you were making a kind of a normative inquiry. I don't want to judge the normative validity of that yet. Although I think formal amendment procedures, by their nature, are designed to be transparent, predictable, open. This, in turn, is designed to be obscure, opaque, irregular. So that might suggest to you how I stand on it.
Kate, do you want to add something?
I'll just add something very brief. I think that Part 5, so the amending formulas don't actually contemplate or aren't really that interested in the success of the particular proposals down the line, whether or not the particular proposals for Senate reform will be successful or how they're going to play out. The amending formulas are about process, and they're most concerned with the moment of enactment. And so the question then is, who has the authority to enact the particular proposal, rather than is it going to be successful in any way down the line. And with respect to Bill C-7 and the legislative framework for elections in particular, the question isn't how it's going to operate at the end of the day. It's does Parliament have the authority to enact that legislation, given whether or not it's going to have make a substantive change to the Constitution itself, to the constitutional configuration of the Senate. And of course, that's the key dispute between the parties.
I don't have anyone. Oh, Jamie, do you want?
I have 3 little comments here. One, I'm wondering if any of the panelists would be prepared to comment on whether we've received any clues from the Supreme Court Act reference as to how the court might be thinking of resolving the Senate issues. So I think that's kind of interesting to speculate about. Second, and Richard, I apologize, I haven't read your paper. I am going to read it and some of your other scholarship, because it's a very interesting area. And of course, the history of amendment in Canada is particularly interesting. So I'm just thinking out loud, but I think there's the whole history of convention in Canada is a really major influence, and the role of, I don't know how convention fits into the whole idea of constructive unamendability, but there might be something there that tells a really interesting story about Canada in particular. And then my third thing is just something that occurred to me as I was listening. And, I go back a long time to Meech Lake Accord and Charlottetown Accord, and sort of that's where I cut my teeth in constitutional law many, many years ago. And, what was interesting about those exercises is that, well, we learned that the Constitution was unamendable, but it was sort of through a different kind of a situation in which those seeking to amend the Constitution gratuitously made it gratuitously more difficult for themselves than they needed to. So what I'm struggling to say is that there was a sort of an element of gratuitous unamendability because, I mean, both the Meech Lake and Charlottetown, they were both a package. And so it was all or nothing, and the requirement of unanimity, for instance, in Meech Lake Accord, was not necessary for all parts of the package. So I don't know whether that forms part of your whole theory of amendment, how you're evolving it and so on, but I think once again there's really a lot of fascinating stuff in history which might give you some it might give you some material to sort of reflect on the interplay of theory and principle with experience.
Did you want to say? Go ahead. I'll defer to you. Just go ahead, Warren.
Age before beauty. All right, well, very quickly then, I won't make a comment on whether the jury's still out on whether the Supreme Court Act reference, the degree to which it will influence, obviously the court's thinking about the amending procedures, and that's as far as I would go. Just on the third point, because the second really addresses, I think, Richard's work, on Meech Lake and Charlottetown, the only thing I'd say, and I made this point in another paper, so it's not controversial, I think, is that we ended up with the worst of all possible worlds. We ended up with an amending procedure that is not even in Part 5, and that is unanimity within 3 years. That is combining Section 38, the general amending procedures requirement of 3 years, with unanimity. Where is that set out in the Constitution Act? And that may explain as well why the current government preferred an incrementalist approach rather than an all-or-nothing package that would bring us to the constitutional precipice.
Are we still abiding by the rule of age before beauty? If so, I think I have to go before you, Kate. So on conventions, amendment in Canada, I think, is the most fascinating question. The history of Canada is a history of constitutional amendment, is it not? So I have some thoughts about convention. In fact, I have a paper coming out. It's called Constitutional Amendment by Constitutional Desuetude. The idea that entrenched provisions in a constitution can fall into, they just lapse and they lose their validity, their political validity. And so this is a story that we can tell in Canada because we have a constitution that is a hybrid in so many different ways, written, unwritten, entrenched, partly unentrenched. So it explores the very question that your question alluded to. So I'm happy to continue talking about something, but just one more comment about Meech Lake and just the other things of interest about amendment in Canada. There's a wonderful book by Donald Lutz, and if there are students in the room here thinking about research projects, write about amendment. There's nothing more interesting than amendment.
I agree.
And get in touch with me if you want questions or ideas about what to write about. There's a wonderful book by maybe the leading theorist of constitutional amendment in the world. His name is Donald Lutz. He's a political scientist. And he wrote a book called Principles of Constitutional Design, which explores, among other things, the difficulty and rigidity of formal amendment around the world. He comes up with a ranking of amendment difficulty. And what's number one on his list? The United States, right? The United States is thought to be, by conventional wisdom, the hardest constitution to amend. There's an asterisk, though, in his study. And the asterisk is, I didn't include Canada because, and here's why, because I didn't know where to find its constitution. Part of it is written, part of it is unwritten. What is the Constitution of Canada? How do I judge its amendment difficulty? Had he included it in the study, I think it would have been number one. It would have been the hardest to amend, and we know why. There are many, many political actors whose careers have fallen as a result of their amendment failure. So there's a lot to study about amendment in Canada. I'm so glad that I now have a partner in crime who's actually very seriously interested in this and writing so much about amendment. But yeah, convention I think is going to be the focal point of future studies on constitutional amendment in Canada because formal amendment, I think, the ones that we really care about are impossible.
I'll just say a few comments on your first question about predictions. Even though this morning at breakfast, Warren told me that predictions are a fool's game or a mugger's game or something. He had mug's game, yeah. But I'll go for it anyways. At the beginning, or right after the Supreme Court Act reference, I was expecting that the two decisions would come out together, the Senate reference and the Supreme Court Act reference, because the constitutional questions in the Supreme Court Act reference certainly cover the same territory that the Senate reference cover. There was, of course, more time pressure to come out with the Supreme Court Act reference first. I guess nobody is really chomping at the bit for Senate reform. I think the Supreme Court, I'm going to call it now the Nadon reference, because Supreme Court Act reference is just too long. So in the Nadon reference, certainly the language that is used shows that the court has certainly been turning its mind to the Senate reference, that it must have, at least to some extent, all of its ducks in a row for the Senate reference, because it couldn't, because of the impact that the Nadon reference decision has on the Senate reference, because of the links between the two, they had to have all of their Senate ducks in a row before releasing the Nadon judgment, because they don't want to end up contradicting themselves in the second judgment. And it's very clear that the court has constitutional architecture on its mind, that it's taking that very seriously, that it sees constitutional architecture, including, well, I would say that includes the place of the Senate in our constitutional architecture. It has that on its mind, and that is a substantive matter, right? It's not just an interpretive tool, but that's a substantive matter in the Constitution. And I think that points to the idea that abolition of the Senate will certainly go to the unanimity procedure, to Section 41. And there is a comment that the court makes in the Nadon judgment about the abolition of the Supreme Court and how that would necessarily go to Section 41. And I think the same will play out with respect to the Senate. And I'll stop there, actually. I don't want to get too far into the fool's game that Warren warned me against.
Just make one final little comment and then we should break. It seems to me Richard's idea of constructive unamendability is extremely applicable here in Canada, because after Meech Lake and Charlottetown we kind of learned that we really couldn't operate these procedures. And so the key to understanding, I think, the government's role in the Senate reference is they tried to find things they could do without entering onto the multilateral process, because they knew the multilateral process would fail. And that's unfortunate from one point of view, but I think we're going to have to see a lot more of that. We're going to have to see, it may be a fraud on the Constitution, but we're going to have to see more ways of kind of skating around these multilateral amending procedures, because we know they're not going to work. And maybe at some time in the future, politicians will figure out how to make them work, but right now, they won't work. It's 12:45, and I know everybody cares about lunch, but I don't know what you're supposed to do about lunch. Do you want to? Jamie knows something.
First, I would like to thank Peter, Kate, Warren, and Richard for a fantastic panel this morning. This business of constitutional amendment in the particular and in the theoretical is really quite fascinating. And so we look forward to the Senate reference emerging from the court and seeing what the court has to say about it. But in the meantime, we've had a really good panel here this morning. I want to thank the panelists for their work at the conference and their contribution. So let's do that first.